Thank you. Please be seated. Good morning.
May it please the court, we're here this morning on a couple of motions in 2021 GS 15, 592, 593, 594, and 595. Those are the two murder charges and possession of a firearm during commission of a violent crime charges against Alec Murdaugh for the murders of Maggie and Paul Murdaugh. We're here for the state's motion for a protective order so that...
Your Honor, we're not here for that. We're here for the defense motion to compel. And I object to the state trying to hijack this proceeding by taking over and saying this is for their motion for protective order. We made a motion to compel weeks before they made their motion for protective order. And I'd ask the court to allow us to go forward with our motion to compel.
Your Honor, both motions are to be heard today, and I think that if the motion for protective order is addressed, it makes any motion to compel moot, because, of course, as the state has been clear from day one, we've been ready to provide this discovery, but because of the sensitivity of the matters here, we think it's appropriate, out of an abundance of caution, to seek a reasonable and minimally intrusive protective order so that the discovery can be provided. The second it's provided, there is no need for a motion to compel.
Please, the court, Your Honor, we have a motion to compel. We filed. We'd like to be heard on it, and then if they want to respond, Your Honor obviously could hear that. But we filed this motion weeks after they failed to comply with Rule 5 and Brady, and to just ignore that, I think does a disservice to this court and the criminal justice system.
The only reason why those...
Your Honor, I'm not done. If I could be heard without being interrupted and hijacked by the state as they continue to try to hide the ball on this case, I'm sorry if I appear upset, but I can tell you that every time we turn around, they're trying to hide something. And if we could just have 15 minutes to address the court and call a witness, we could get to it.
Your Honor, to set the table appropriately, I think the protective order, which is what started this whole issue, is the way to set the table. And I would point out that Mr. Harpootlian stood up and interrupted me as I was trying to set that table.
Your Honor, that table has never been set because they won't comply with Rule 5. They could have raised this protective order issue 7 weeks ago and didn't do it. So
that's because the defense had agreed to it up until after hours on Friday.
And if I would be allowed to finish without being interrupted, I know he's head of the statewide grand jury. I know he's a very important guy. But my client has a right to a fair trial, and a fair trial means a motion compel to find out what it is we're trying to compel and not have the Attorney General continue to try to hide behind whatever this is, protective order. Your Honor's opened this courtroom. You issued an order denying a gag order. You issued an order saying this is going to be a public trial, and yet the Attorney General continues to try to make it a Star Chamber event. I'd like the ability to make my argument and call one witness.
Mr. Waters, if you will be seated, and I'll not have both counsel arguing with each other and not to the court. Now, Mr. Harpootlian, this is before the court is a motion to compel and a motion for protective order. That's before the court.
Is that procedural?
Yes, sir.
Thank you. Your Honor, by way of explanation, and I'm going to be extremely brief because we have filed, again this morning, we have filed a very exhaustive memorandum describing the issue.
We received it 5 minutes before the beginning of court.
And I apologize, but we got the state's position late Friday afternoon. We worked on the weekend, and we couldn't file it until this morning. We actually emailed it, and apparently there's some, maybe it was too large or whatever. But suffice it to say, it points out all the things that we pointed out in our initial motion to compel. And that is, under Rule 5 and Brady, we're entitled to discover materials, prepare a defense. The question is, who's going to make the decision on what we get? And, Your Honor, we're going to be in this courtroom over and over and over again. If Your Honor enters a protective order, I'm not going to argue about that at this moment, but clearly, I've been involved in literally dozens, if not hundreds, of murder cases in my career. I've never seen such a thing in a murder case. Now, statewide grand jury? Certainly, there's a grand jury. There's protective orders in place. I get it. But this is not a statewide grand jury case. So why we don't have what we asked for 7 weeks ago? The 30 days is not the minimum, it's the maximum, number one. Number two, I'd like to put one witness on the stand to sort of explain where we are.
You need to explain who this witness is and the need for a witness.
Yes, sir.
And a motion to compel hearing.
Captain Ryan Neal, he is with SWAG. He's been involved in this process and the gathering of the evidence, which I think would explain to the court how easy it is for this evidence to be produced. 10 minutes max.
Your Honor, I don't see any need for a witness at this time. I don't think that there's any factual issue in dispute for the purposes of this hearing as to the evidence that was gathered. These are legal issues as to whether or not a protective order is appropriate and whether or not the defense's motion to be compelled should be granted. And there's no reason to even get to factual, which he's failed to identify a viable factual issue that's in dispute. I know Mr. Harboolian would love to get a witness on the stand, but to make this clear, the state wants nothing more than to have a fair trial in this case. I don't want to have to try this case more than once. I want to do it right the first time. But having this sort of, evidentiary hearing this early on when there's no factual issue in dispute is completely unwarranted. Let's get to the legal issues, and if Your Honor is satisfied after the legal argument to make a ruling, that's all we need to do here today.
This impacts the legal issue. We're not quite sure what we're asking for. I think this would make it clear to you what we're asking for and whether or not it's easily available. Again, 5 minutes.
Rule 5A2 provides that the disclosure rule does not authorize the discovery or inspection of reports, memorandum, or other internal prosecution documents made by the attorney for the prosecution or other prosecution agents in connection with the investigation or prosecution of the case, or of statements made by prosecution witnesses or prospective witnesses. A motion before the court to compel discovery, should the court grant the motion to compel discovery, the state, and as the court is bound to compel, the state then must produce discovery. The defense does not get an opportunity to interrogate state's witnesses concerning the nature and extent of its investigation, so I'm not going to allow a witness for that purpose.
Your Honor, make one comment. I'm not arguing with your position. In the memorandum that we received on Friday, the state points out that they don't want other suspects who were interviewed disclosed. Well, if they interviewed other people that they considered to be suspects and excluded them, why aren't we entitled to them? Why aren't we entitled to that, to know who they suspected, why they suspected them, and on what basis they excluded them?
They absolutely will be, Your Honor. Once we have the rules in place for the discovery.
Well, the rules are in place. It's called Rule 5 and Brady. So, Your Honor, what I would say to you is this. I don't trust the state to honor the rules. They haven't so far, as we point out in our motion. I'd ask the court to appoint a special master to supervise discovery in this case. A number of retired judges have done this in the past, not because you can't do it, but because it would consume all of your time to do it. Someone like retired Chief Justice Toll, there are a number of them out there that do it in civil cases all the time. So I'd ask the court to consider appointing a master to supervise the state in reviewing it and assisting them in reviewing the documents, make sure we get what we should get. Thank you.
Your Honor, Mr. Harboolian put in his latest filing that, as Your Honor pointed out, we got 5 minutes before this hearing started, that he knows he's worked with me on a number of cases and knows I don't play fast and loose. They put that in their motion. Knows that I'm not responsible for any leaks. They put that in that motion. They will get everything, okay? I don't play fast and loose with discovery. I would rather give them everything because I don't want to be down the line, with anything that I had that they could potentially have found useful. That's how I play the game, and they both know this because they've had experience with me before. And as soon as we can get a ruling on the protective order, because of the extreme sensitivity of this information, this information, Your Honor, is probably worth 6 to 7 figures. I am not at all, and I put this in my motion despite their recent response, at all worried about Dick Arputlian or Jim Griffin selling this information. I'm not at all worried about that. But the problem is that inevitably a number of people, as the case is prepared, have to get access to that information. And the whole point is to have this not fall in the wrong hands. This case is unique. It's unprecedented in South Carolina history, in as much as it combines violent crime with alleged corruption of someone's law license on a scale that's never been seen before. And, Your Honor, if not this case, what case would a protective order be appropriate with the intense media interest that there's there? None of this is to preclude a public trial. Everything will come out in the open. All this is meant to do is have it come out when it's supposed to, and that's in this courtroom. And again, defense counsel was completely on board with this up until after 5 p.m. on Friday before the discovery was due on Monday, and they changed their mind. And I feel before I'm the one to authorize and press a button and disseminate this information that has such value to at least out of abundance of caution say, Your Honor, if not this case, what case is a protective order warranted? And there's a few reasons for that, Your Honor. I think, and I've cited in there the Smith case, which is a Southern District of New York. Manhattan is probably the most important district, or one of them in the nation. And there was an exhaustive discussion in a very high-profile public corruption case of all those particular issues. And in that particular decision that really synthesized a lot of other decisions, first thing they note is that there's no First Amendment or very limited First Amendment aspects to pretrial discovery. This is not what's going to come out in court at the time. This is pretrial discovery. So that's not really a concern for Your Honor. So the other concern is whether or not there's any sort of good cause in the case for the court to authorize a protective order. And again, I would say, given the unprecedented and unique nature of this case, if not this case, what case? But it's pointed to a number of factors that are relevant. And one of those is, of course, is protection of the privacy and the rights of third parties. And, Your Honor, I think in this particular case, we have in this evidence is chock full of such information that should be protected. There are phone dumps from a number of people, from victims, from witnesses. Those phone dumps have all kinds, are complete. They have all kinds of communications with people. Their contact information is in there who may have nothing to do with this case, but we're just contacting that phone. But I would not want to get into the process, which would take forever, I might add, Your Honor, of sitting there and trying to separate the wheat from the chaff and the phone dumps before it was provided to the defense, which then they would complain that the state is withholding discovery. I'd rather them have the whole thing because I don't know what they may see in there that they think is relevant to their defense, which is their right, which is why I don't want to be separating wheat from the chaff. Let them look at all of it and decide what they think is relevant. That's how I play the game, and they know this. Your Honor, there is information in there. There's tons of personal identifying information in there that a protective order would satisfy any issues as it goes to that. And then, of course, I did mention there's excluded suspects, that premature disclosure of which would be damaging, but none of that is to preclude them from having it. They are entitled to it. They're entitled to vet that themselves and to raise those issues if legally appropriate. They can do that all they want to, but it is appropriate that those people's identities be protected under protective order unless and until those issues become relevant in trial. And that could be after Your Honor rules on various legal issues relevant to that. That's a huge right of a third party. And then, of course, most of the witnesses in this case who have their MOIs, memorandums of interview, their recordings of their interview, all the rest of them, they don't want to be in the news unless and until a trial happens. And that's their right. That's important, something to protect, Your Honor, that they don't need to have intense media focus on them until and unless their testimony becomes relevant in a trial. These are all very valid concerns alone to justify a protective order. The second issue that was mentioned in the Smith case is ongoing investigation. And while this has been a long-standing investigation, as Your Honor is aware, there are related cases that are going on. And additionally, in any complex case, the case always remains ongoing as things develop as you move to trial. That's an inevitability in any sort of complex case. In this case, with all of the unprecedented interest, that justifies protection. Additionally, there are related state grand jury cases which are already subject to the standard protective order, which is very similar to the standing protective order that's in the federal district court. They have a protective order as to everything. And because there's so much overlap between the evidence in the state grand jury cases and this murder case, where one of them represents a long-standing course of conduct, of criminal conduct, alleged criminal conduct that culminated in ultimately the allegations of what happened on the night that Paul and Maggie were killed. Because of that overlap, it only makes good prudent sense to have all of the information subject to similar rules going forward. And then finally, of course, is to protect the process. And again, my concern is not Dick Harpootlian, it's not Jim Griffin. I've worked with both of these people, and they both said the same thing about me. But inevitably, when it's not authorized, it's not directed, inevitably, though, this information could end up down the line as the case is prepared in the hands of people whose motives aren't as pure. And all of this is done is to protect that, because this information literally is probably worth over $1 million to an unscrupulous hands. And I think we have to protect it for that reason. I say again, Your Honor, if not this case, what case would a protective order be appropriate? We have been ready, and the defense knows that. We were having conversations with them the week prior. We were talking about a protective order. They raised not the slightest concern about it. They even edited the protective order and cleared it for submission to you, and then changed their mind. And that has been the only delay, and while the button hadn't been pressed at the discovery center. There's been no improper motive, improper collusion on the part of the state, none of that. And then as far as the issues of leaks, Your Honor, I have not leaked a thing, okay? I am not aware of anyone who's leaked any substantive evidence or any violated Rule 3.6 in this matter, okay? Leaks do nothing but make it look amateurish, make it look messy, and provide strategic opportunity for the defense. Those who know how to handle a high-profile case don't leak, because it does no good whatsoever, Your Honor. And the only thing I am aware of two indiscretions about procedural issues that were immediately addressed. And in both of those instances, it was just simply about a step in the process, and both of those were unauthorized, undirected, and were immediately addressed. It had nothing to do with any substantive evidence, nothing to do with any state grand jury evidence, and nothing like that. The way that we practice state grand jury, our practice is very much different from the feds. The feds don't put as much they don't tend to put as much witnesses in front of the grand jury as we do. As Your Honor is well aware, because you're, of course, serving as the state grand jury judge, we tend to put a lot of witnesses in there and exhaustively vet that testimony under oath, and we believe that there's significant advantages to that. But while the attorneys and law enforcement and the jurors and the court reporter are all sworn to secrecy, the witnesses are not. And we ethically have to advise them on the record that you're not subject to this secrecy, although we ask you to use discretion if you talk at all. So if sometimes there's some reporting in the media that, indictments are imminent, when a number of witnesses have been testifying during a term, many of whom are represented by counsel, it's not hard to figure out what's going on. But I'll point out, Your Honor, that many times those reports were made and nothing came out, because the assumption was being made that because testimony was taking place, there were going to be indictments that month, and there weren't. And the same, even in their motion right here, they discussed that as well. They point out some Fitz News article from June calling out the fact that no indictments had been issued when they were expected. Well, that was it. Everybody was looking for when the next Colleton grand jury date was and expecting indictments, but nothing happened. So why in the world would the state be leaking that? We have no motive to do that. All it does is undermine our case and undermine the process. And I'll say that again, Your Honor. I only want to try this case once. And the evidence can come out in the courtroom, and that's the place where it needs to come out. And all the protective order does is ensure, or tries its best to ensure, that that's the case. Thank you, Judge.
Please, of course, Your Honor. Let me sort of address an overarching issue. Rule 5 requires a very specific, as we point out in our memo, a very specific motion as to why a very specific piece of evidence should be put under a protective order. That's not what this motion does. This motion says all of it. Now, for instance, if he were to say, if he's concerned about somebody selling autopsy photos or crime scene photos that we saw out in California recently, somebody got fined a jury found $15 million verdict against them. That's not the issue. If he wants those protected, we're fine with that. In terms of phone records, a protective order on phone records, if Your Honor were to grant a general protective order on all these phone dumps, that's going to inhibit us, our ability to talk to people, to investigate, to issue subpoenas, to do the sorts of things that we're going to have to do to investigate this case. He had the opportunity back in April, the day that we served the motion, to file this motion for a protective order, and didn't do it. He waited till the 30 days to file this, and we got it on a Friday afternoon at 4:15. We looked at it. After we thought about it for a minute, we said, this is ridiculous, and said no. And so here you are today. He wants to put a blanket protective order on whatever we get. Two things. One, we're officers of the court. We're officers of the court. I've never, ever sold, given, handed anybody anything in violation of the rules of professional conduct, ever. Almost 50 years of doing this. Mr. Griffin and I understand, he's a former federal prosecutor, I'm a former state prosecutor, that our job is to represent our client. Our job is not to create a PR storm out there, number one. Number two, these folks over here, I'm sure they would pay money to get something, but they're not going to pay us. And why would we share, again, if it's autopsy photos and crime scene photos, we would agree to a protective order on those. That we only be able to show them to people that we need to show them to, experts, for instance. Not a problem. But for it to come in under Rule 5, D1, and just say everything, he's not made the showing that's required under the federal cases. There is no state cases. Or even under the state rule. We are entitled, as Your Honor has already indicated, we're limited to what we get. Although I think we're going to be litigating a lot about that, because I think there's plenty of ESI information. Plenty of ESI information. That is, in terms of Brady, let me give you an example.
All right, we need to slip in a break here. A spirited hearing, to say the least. We're going to pick it up right where we left off, right after this. Stay with us.
92510.
We're bringing you a pretrial hearing, motion hearing in South Carolina concerning Alec Murdaugh. He's facing murder charges in the death of his wife Maggie and son Paul back in 2021. This morning's hearing comes at the request of Murdaugh's attorneys. The defense wants the state to hand over evidence. The prosecution also filed their own motion, a protective order. Both are being addressed at this hearing, and it has been fiery, to say the least. All and more than we expected. Let's get you back. We're going to pick it up right where we left off.
SLED nobody does paper anymore. Everybody does electronics. So when they prepare an incident report, it goes in, and then it may be changed. And when it's changed, there's metadata that shows how it was changed. And we ought to be able to be aware of what those changes were, to see if it made any substantive difference in what they're saying today. That's why we want the ESI. We want all their electronic data, and so that we can do that analysis. And I'll be happy to enter into some sort of limited protective order on the ESI data, so that we can have that analysis. That's number one. Number two, I have not accused and will not accuse Mr. Waters of leaking anything, ever. However, and the reason I wanted to call Captain Neal was when he met with the family prior to indictments, they were outraged that it was already in the paper. And Captain Neal, according to the family, indicated that the Attorney General's office, some low-level person at the Attorney General's office, had leaked it. Now, I trust Mr. Waters. I don't trust the rest of his office. I just want to make that clear. Because these leaks, some of them were accurate. Apparently, of course, we don't have the discovery, we don't know. But I would ask you, if you're going to issue a protective order, make it only protective as to what we consent to at this point without a specific showing under D1. And D1 requires them to tell you it needs to be protected because of this. And if they're worried about somebody getting the autopsy photos or getting the crime scene photos and trying to profit off of them, we will not be a part of that and would consent to any sort of protective order you want to put in place. As to phone data, as to any other reports, as to ESI, there's no protective order needed except in a very limited circumstance. Now, we're going to be looking for witnesses, and if they redact addresses, phone numbers, social security numbers, we're not going to be able to do that very effectively in 3 or 4 months, which is what we need to do. The last thing I'd say is this. This is not a statewide grand jury case. It is a Colleton County murder case. The statewide grand jury has no statutory authority whatsoever to investigate a murder case. It's not one of the enumerated crimes. It's not one of the things the legislature said you should investigate murders. Child porn, drugs, money laundering, those sorts of things. Now, if he were to say that perhaps this was something that started, as I understand it, started back with the boat case as sort of a public corruption case, and I would note that there's a statute, if I can find it, which says this, that if, in fact, the statewide grand jury begins an investigation, and they want to Section 14.7.1690, once a state grand jury has entered into a term, the Attorney General, Solicitor in the appropriate case may notify the presiding judge in writing as often as is necessary and appropriate. The state grand jury's areas of inquiries have been expanded, or additional areas of inquiries have been added there too. They can go in another direction. Murder's not one of them. Murder's not one of them. Number one. Number two, we've been given on the financial crimes, not on the murder, a number of statewide grand jury materials, not a single order doing this. I can't tell you what I have been given. What I haven't been given was anything expanding the inquiry. If there is such an order, I would suggest we get it. And if it concerns murder, you know, if they took the statewide grand jury and began investigating a murder, these proceedings may be in jeopardy because the statute doesn't allow them to do it. And there's no case or statute that says, well, if the murder was related to something else, you can look into the murder. Murder is not an enumerated statewide grand jury offense. And I don't know that we want to make new law in this case.
So, Mr. Harper.
Excuse me, one second.
I'm sorry, I thought you were done.
I'm not. Am I done? Mr. Griffin says I am done.
Okay. May I go now?
Yes.
Thank you. Your Honor, there's going to be no problem in that regard. I'm happy to share the formation documents with Mr. Harper. I don't believe they've been specifically asked for, but I'm happy to share those with him, but there'll be no issue in that. As Your Honor is, of course, aware, we're standing in Colleton County Court for a murder, and there's a specific state grand jury statute that allows state grand jury information to be shared with a county grand jury or any other appropriate source to aid any investigation that they're doing. And that's actually expressly in the statute, and there's plenty of orders, and that will not be an issue. But I'll certainly provide those to the defense, and they can raise whatever legal issue they want to at the appropriate time.
And we asked for those a year ago. We asked for those a year ago.
Those are not available until they are. You did not. Yes, sir. My apology. We'll certainly, I will be happy to address that with Mr. Harpootlian, and we will. That's not anything that we have a problem sharing, and they can analyze that all they want to. Your Honor, I think it's interesting that he says I've made no showing, but I think I just went into great detail about a showing, and if not this case, what case? With its unique and unprecedented aspects to it, and unique and unprecedented media interest. If not this case, what case? What they haven't done is made any specific showing whatsoever or even claim of how this protective order would in any way impede their ability to prepare their case. And the reason is because it won't. Because the language of the order that I've submitted to you is the one that they approved with their edits. There is nothing intended about this order to stop them from using that information to develop witnesses and whatever else they need to do to prepare their case. It does nothing of the sort. It just puts everybody under the same rules of that's as far as it goes until we get to trial. And so they have not identified, tellingly, have not identified one issue, a specific issue in the language of this proposed order that would impede them in any way. So we're talking about a prophylactic measure of great value and no or minimal intrusion on the activity of the parties. And when you balance those factors, Your Honor, I think I would respectfully submit it's a no-brainer that this order should be granted. one way or the other. Once that happens, once we get a ruling on this, we felt compelled to do out of an abundance of caution, we are going to share all the discovery that we can, that we believe is appropriate, and it's always my practice to be extensive in that rather than restrictive, and both these gentlemen know that. And then, if they have an issue after that, I will be happy to address that with them, and if they are not happy with the response of the state, then we can come back in front of Your Honor and address whatever issue we have then. But we haven't gotten there yet. These are all claims that are premature, trying to, act like that something's happened when it hasn't. There has been no violation yet. There has been no misconduct by the state. There's been none of that. They're just trying to create that before it's happened. Let's get through step one, and if they're unhappy, we'll talk. And if they're still unhappy, they can come to Your Honor and make whatever motion they want to. But that's not why we're here today. Thank you, Judge.
We're here today because 7 weeks ago we asked them for discovery. We still don't have it.
All right, need another break. Get you back in the courtroom right where we left off after this.
What's that? Your Honor, I'm not done. If I could be heard without being interrupted and hijacked by the state as they continue to try to hide the ball on this case, I'm sorry if I appear upset, but I can tell you that every time we turn around, they're trying to hide something.
Disgraced South Carolina attorney Alec Murdaugh back in court this morning. Murdaugh is accused of murdering his wife Maggie and son Paul back in June of 2021. We'll get you back into the motion hearing right where we left off, and boy, it's been a doozy so far.
And by the way, under their order, we can't leave discovery with our client at the jail to read. Now, just wait just 1 minute. Typically, he's dealing with a bunch of drug defendants, I understand, that have co-defendants down at the jail, and they don't want them sharing. It's a one-defendant case. Why can't he have the time to examine the data at the jail? Now, that's where they want him. That's where he's kept. We have to sit down there with him and read it with him every day. This is ludicrous. And again, what are we protecting it from? Well, who are we protecting it from? Again, we've agreed. He says everything needs to be protected. We've agreed certain things perhaps need to be protected we don't have a problem with. But if Your Honor issues a protective order, this is not, certainly they can share material with the state grand, with grand juries, county grand juries. They're not supposed to be investigating a murder case. They're not supposed to be investigating a murder case. The statute does not allow it. So if they're out there asking witnesses about the murder in a statewide grand jury case, these proceedings are in jeopardy. So what I would ask, getting back to the original issue, is don't issue a blanket protective order. If there's certain things we think, maybe autopsy photos, maybe crime scene photos, restrictive use of sharing cell phone records. I don't have a problem with that as long as we can share them with experts and issue subpoenas. We can't issue subpoenas. We'd have to come to the court for an order, a forthwith order to get material because we don't have the subpoena power. And one other thing I'd like to say is this. They charged him with murder. What they're telling us today is they're still investigating it. They're still investigating the murder they've charged him with. They didn't have enough when they charged him. Again, Your Honor, this is some sort of game that's going on here. And he used the word game. That's not my word. This is not a game. It's his life. It's justice. It's the quality of justice in this courtroom, in this state, and it ain't a game. Thank you.
I agree. I apologize for using that word. That's exactly what I'm trying to protect here is the quality of the process in this courtroom. And I absolutely realize that. But as far as his concerns about the state grand jury, again, he can get the orders and he can make whatever legal arguments he wants, but there's not going to be a problem there, Your Honor. But that's another issue down the line. We are here in a Colleton County murder case, and I understand that very well. I don't just do grand jury cases, and that's not where I started from. So that's not, the blending of those two is not going to be a legal problem, but it's really not any issue that we deal with here. Your Honor, ultimately, as it relates to Alvin S. Glenn, what better example of what I'm talking about with information that is worth 6, if not 7 figures than the idea of leaving that information in Alvin S. Glenn?
We're not going to leave autopsy photos or crime scene photos at the jail, Your Honor. We're not going to do that.
And so, in the past, in cases like this, with like Bloods and Hell's Angels, and Mr. Griffin, I'm sure, is familiar with this. Can I
One
finish?
defendant case. I'm sorry, Your Honor, I apologize. I'm losing my...
None of this is too meant, and I'm happy to do anything to facilitate the defense's review of this material and presentation, and they know this. And Mr. Griffin is a former federal prosecutor and knows that protective orders are standard in almost every case, and they go just fine. Okay? And so that's really why they still haven't identified any specific problem. But without an SQL, we can set up maybe a secured laptop and ring you. This has been done before, a manner which ensures that information cannot be disseminated and then can be retained. There are things that we can do to allow them so that Mr. Griffin or Mr. Harpootlian doesn't have to sit in front of the defendant for hours while he reads that discovery. I'm not trying to impede them. These are minimally intrusive, and Mr. Griffin knows as a former federal prosecutor that it can be done. It's done all the time in virtually every federal criminal case in the District of South Carolina. And that's all we're asking for. Again, Your Honor, if not this case, what case? Thank you, Judge.
Your Honor, may I address the court since I've been addressed? There are routinely in federal court protective orders that, and mostly multi-defendant drug cases, and it's mostly for security purposes, for retaliation against witnesses and snitches and things of that nature. And there are restrictions in those cases. It's not every federal case, but in those type cases where the defendant is not permitted to have the material at the jail. But I can tell you, Your Honor, that the Alvin S. Glenn Detention Center no longer houses federal inmates because they had a problem making their clients accessible to the federal public defender's office. And as my understanding, every federal defendant has been, a pretrial detainee has been removed from the Alvin S. Glenn Detention Center. I think they moved them down to Bamberg because the visitation is so restrictive there. They have gotten better, but it's still 1 hour at a time, and you're in a room with other lawyers. You're in a pod, open pod, with other lawyers, and get an hour at a time. And there's a bulk of information that Mr. Murdaugh, who is a lawyer, who can help us if he has time to review it in his cell, that we would certainly not give. He doesn't want to see crime scene photos, Your Honor. That's the last thing in the world he wants to see. But he needs to assist us in the defense of his case. And the conditions at the Alvin S. Glenn Detention Center are not conducive to that. If we have to meet with him for 1 hour to look at some discovery and then wait, you have to give 48 hours notice to schedule an appointment. And it's just not conducive to that. Thank you.
Your Honor, first of all, he was a lawyer. Secondly, the fact that he's in Alvin S. Glenn, while that might provide some complication, it's not the state's fault. That's his fault. And that's on him. I'm happy to facilitate whatever I can to provide a reasonable review mechanism, but if it's an inconvenience to some extent, that's not on the state. That's on the conduct of the defendant.
Why is Murdaugh in Alvin S. Glenn as opposed to Colleton County?
He's currently there on the $7 million state grand jury bond.
The judge is going to make a ruling. We'll have the ruling at the top of the hour. Final thoughts, Jamie White. Boy, quite a contentious hearing.
Yeah, it has been. Excuse me. I agree with the defense here. I think the prosecutor has not put forth any basis for delay or interference with providing the discovery. Ted, the prosecutor should not be the gatekeeper here. They're arguing, well, it won't be that big of an inconvenience. Well, it shouldn't be any inconvenience. They've made some stipulation that they're willing to protect some of the more sensitive items, such as photographs and crime scene evidence, and to hamper them with a jury trial set just a few months out. As far as some of the other records that have been described, I think it's completely inappropriate, and I agree with the defense. I'll be shocked if the judge allows this barrier to be constructed.
Melissa, quickly, as we approach the top there, you agree with Jamie, or you think that there should be a protective order here and ironed out before this?
I think based on from the state's argument, I think a protective order is appropriate. It doesn't seem like they're trying to hide the ball. They're saying we want to give them everything. We don't want to be responsible for coming back to you, Judge, every single time we think a protective order is needed for a particular piece of evidence. We want to give them everything, make sure it doesn't leave their defense team or the defendant. We just don't want it leaked to the general public, and I don't think that's unreasonable.
All right, we'll see what Judge Clifton Newman decides at the top of the hour here. We'll get a break in. We want to thank Jamie White for his time and expertise. As always, great having him along with us. The judge is going to make this decision. We also have our eye on the courtroom in Florida. Nicholas Cruz, of course, his defense still trying to convince a jury not to send him to death row, monitoring both courtrooms. Back with more right after this. This is Court TV, your front row seat to justice. Top of the hour, welcome back to Court TV Live. Oh, we've been bringing you this very emotional pretrial hearing in South Carolina. Very spirited. Alex Murdaugh is the defendant. He faces murder charges in the deaths of his wife Maggie and son Paul back in 2021. This morning's hearing comes at the request of his attorneys. The defense wants the state to hand over evidence. The prosecution also filed their own motion, a protective order motion. It's been a fiery morning indeed. These two right in there have been going at it. You haven't missed a minute of it. Let's pick it back up right where we left off. The judge is about to make his ruling. Here we go.
Well, Rule 5 of the South Carolina Rules of Criminal Procedure provide that the state must disclose evidence to the defense, and it's outlined in the rule what must be disclosed. The court has cited the portion of the rule that indicates the information that is not subject to disclosure. D1 of that rule provides that upon a sufficient showing, the court may at any time order that the discovery or inspection be denied, restricted, or deferred, or make such other order as is appropriate. Upon motion by a party, the court may permit the party to make such showing in whole or in part in the form of a written statement to be inspected by the judge alone. If the court enters an order granting relief following such an ex parte showing, the entire text of the party statement shall be sealed and preserved in the records of the court to be made available to the appellate court in the event of an appeal. As I said at the beginning, we have two matters before the court, the motion to compel and the motion for protective order. The rules provide that the prosecution shall respond to the defendant's request for disclosure no later than 30 days after the request is made, or within such other time as may be ordered by the court. In this case, on the 30th day, the parties entered into discussions, negotiations regarding an agreement as to a protective order. The parties could not agree, and immediately thereafter, the defense filed a motion to compel. The state then filed a response indicating that that disclosure was delayed based on the parties' inability to enter into a protective order. So in essence, both matters are merged into one, in a sense. Now, the state must provide discovery, and the state has indicated a willingness to provide discovery. Of course, it's automatic that the state must provide discovery, and as the Attorney General indicates, he is prepared to push the send button and provide the discovery requested. provided that some reasonable limitations be made in connection with the dissemination of information that should be protected. Information that typically would be restricted in a high-profile case, and other sensitive information. In this case, I have been assigned to preside over 80 indictments of various sorts. Since the initial bond hearing, Mr. Murdaugh has been indicted for several other cases involving his former law firm and family, involving matters involving the law firm necessarily involve privileged attorney-client information, investigation beyond that deals with sensitive crime scene photographs, and based on the nature of the indictments having been issued since the bond hearing, and the fact that that grand jury has not ended its service upon a proper showing, which appears to be the case of an ongoing investigation, it would be improper and an improper intrusion into that investigation for there to not be some restrictions placed upon dissemination of evidence in this case. There is pending in the case involving Mallory Beach, pending lawsuit against Mr. Murdaugh and others involving dissemination of sensitive information. Mr. Harpootlian referenced the $15 million verdict awarded Kobe Bryant, the spouse of the late Kobe Bryant and the late Gigi Bryant. Mr. Harpootlian also referenced the notion of a special master involving sort of a hint of what's going on in Mar-a-Lago. So these issues abound as to what information should or should not be restricted in a case such as this. Now, the court has the responsibility to, an independent responsibility and obligation to avoid the creation of as some courts said, a carnival-type atmosphere in a case of this nature. And I will do all that I can to limit that. But in this case, we've gone from the parties seeking an agreement regarding, in effect, a gag order just several weeks ago to being at extreme odds at this point, claiming various violations of the rules. Now, extrajudicial statements are permitted, but they must be limited in accordance to reasonable restrictions that ensures the rights of both the state and the defense to the fair trial, in addition to the right of the public to receive as much information as is possible. In most instances, that information becomes available during the course of the trial and not pre-trial. Therefore, in this instance, I am ordering the state to compel with discovery, comply with discovery forthwith. I'm also issuing a temporary protective order restricting the defense from disseminating any information provided until the court has issued a more formal, more permanent order. Of course, any order issued by the court may be modified, and this does not in any way limit the parties to make extrajudicial statements in accordance with the rules, nor does it restrict the parties from addressing any disclosing any information independently discovered, nor does it restrict the parties from addressing information already in the public domain, such as have been referenced in this hearing today. I'll have Mr. Waters submit to the court a proposed order. Mr. Harpootlian and the defense would have an opportunity to review and comment on that. But this is a case that cries out for the issuance of a protective order, not a blanket protective order, but one that addresses the issues most relevant in this instance. Mr. Harpootlian.
Your Honor, one other matter that is part of this is, as Your Honor knows, all the search warrants in this case were sealed. We've been indicated to us that the prosecution would unseal those search warrants so that we could see what the affidavits looked like. And even though the sua sponte order issued by Your Honor and others only govern the affidavit, we've never seen the results of any of those search warrants. So, Your Honor, could you also order the state to give us the unsealed search warrants?
Yes, sir. Obviously, and the state has been clear from day one. If we get the protective order addressed, which of course Your Honor just did, then we're happy also to agree that those search warrants should be unsealed pursuant to the protections of the protective order, as Your Honor just discussed.
And Your Honor, would you get us that draft of that protective order by close of business today or first thing tomorrow morning so we can get the show on the road?
Glad to, Your Honor.
And the court orders the unsealing of search warrants to include the providing of affidavits and returns to the search warrants.
And Your Honor, they were not only issued by you, but for instance, Judge Mullen issued some, other magistrates issued some. We're talking about all search warrants.
Yes, I believe the order of the Supreme Court giving you all pretrial authority, that would apply to any order regardless of which judge issued it.
And Your Honor, we will be able to, if we have a laptop that we can take to the jail, not leave written documents down there. As soon as we get this material, can we begin that process with Mr. Murdaugh?
Mr. Waters and Mr. Griffin both mentions a standing order regarding discovery in the federal court of this, at least the Florence Division, one of which I have received a copy of. And the discovery, that standing order governing discovery states in part, under no circumstances are copies of these three categories of discovery materials be released into the jails. I certainly understand there's difficulty with a person in jail reviewing discovery, and some special provision must be made in this instance to address those issues. But it's a no-brainer that sensitive, private, and other related discovery materials should be restricted, particularly in a jail.
So if we have a laptop with non-statewide grand jury material on it, just what we get on the homicide case, can we take that to the jail, have somebody sit with Mr. Murdaugh, not let him look at it, and then bring that laptop back. Can we do that?
That's generally the reading room procedure, and I'll be happy to discuss that further. I don't believe there's going to be an issue that's coming up with something along those lines. It's been done before.
We need to have a hearing before the jail folks. We can have a hearing before the jail folks.
Well, we've talked to the jail folks extensively. The problem is not the laptop. The problem is not access. The problem is getting more than 1 hour every other day. And that is the problem. And perhaps the Attorney General would offer us a conference room at the Attorney General's office. We could spend 7 or 8 hours a day with Mr. Murdaugh reviewing documents. Or they could bring him to my office. I don't have any problem with security guards coming there during the day. But again, this is not due process to get to see it 1 hour every other day.
I'm happy to consider all reasonable options. Obviously, in the end, I'm going to defer to the security concerns of those who are responsible for the custody of the defendant.
The court will address any and all problems as they arise.
Thank you, Judge.
Thank you, Your Honor.
All right, thank you. Anything further?
Okay, what started out as very contentious seemed to work itself out.